Hello and welcome to the Rogers Brief. I'm Adam Rogers. Thank you for watching and thank you for listening. I'm going to give a summary of sorts of what we've heard so far over the first 6 days of proceedings in the Mass Casualty Commission. And I'd put some of this under, I'm going to talk mostly about the process and procedures that have been followed so far. And you can put this under the category of the old Marshall McLuhan saying that the medium is the message. Well, the procedure that the Mass Casualty Commission has been following is really affecting the content. And in my view, it's their disorienting approach to the evidence presentation so far is really unfair to the viewing public, and also it's not at all trauma-informed, as is in their mandate. So we're now 6 days into the Mass Casualty Commission proceedings, and so far I think it's fair to conclude that the process designed by the commissioners seems intended to sap as much dramatic interest as possible from the proceedings, as though that were somehow synonymous with being trauma-informed. So what we've seen so far is that witness statements have been, and officer notes have been published on the website in full. The parties, the non-commission parties, have been forced to beg the commission for witnesses to be called. The lawyers, in doing so, have had to give advance warning of their lines of questioning for these witnesses, or proposed witnesses. And then, as part of that process, the police have really tried to exploit the trauma-informed mandate into what they see as what should be a blanket exemption from any police officer having to testify. And then maybe the biggest issue is that in 6 days of proceedings so far about Portapique, and in all the talk about Portapique, we have yet to hear a single word spoken by a person who was actually there. Okay, so I want to talk about all of those things. First of all, the statements. So if you look on the website of the Mass Casualty Commission, you'll see what is really a treasure trove for the curious. Statements given by witnesses, sometimes multiple statements, officer notes, handwritten notes and reports, lots of documents, maps, other things that would normally be provided to a lawyer as part of the disclosure. Now, these statements are not typically given to the public, and instead each lawyer is given a copy of the statement, and then you would have the witness appear in their examination in chief, go through their statement, go through everything that they witnessed, and then each of the other lawyers, however many, 4 or 5, maybe a few more in an inquiry setting, would have an opportunity to cross-examine and use the statement or any parts of it that they feel are relevant to the questions at hand, or ask questions that have nothing to do with anything that's in the statement. But instead, we don't have that. The statements have been provided to the public and to everybody, and it's a bit of an issue because there's stuff in there, there's sensitive information, things that are otherwise embarrassing that may not be germane at all to a key fact, and yet here they are exposed to the public. Like in some of the statements, the people in the community are talking about romantic relationships, affairs, it seems, different interpersonal relationships that may not have anything to do with any relevant fact. And then in one of the staff sergeant's reports, Staff Sergeant Halliday talks about his initial suspicion that maybe it was an officer that had gone crazy and started shooting people, and named the officer, and it's in the statement. So why did he think of that particular officer? Was there something going on? It sounds like it. Whatever it is, it might be something sensitive that probably has nothing to do with the situation. And yet it's public. So certainly doesn't appear to be trauma informed in that regard. Maybe more broadly speaking, I think the Commission needs to understand, or maybe they do understand, that there's a variety of interests at play here. And the public, the public interest in, the interest of the members of the public, in the Mass Casualty Commission proceedings is part of that. It's part of the field of battle among these various interests. You see this playing out in each witness. The parties, the members of the families, they want a certain witness to be called, and the commission, the police lawyers take the opposite view. So there's definitely decisions to be made, and important decisions to be made on the part of the commissioners. But the field, it also includes the public interest. So the parties and the families need the public to be involved and to be interested, because after the commission has issued a report, then whether the government is going to enact any of those recommendations is going to depend in large part on how much public pressure they're facing to do so. And if the public has tuned out, or for whatever reason has lost interest in the matter, then that only serves the vested interests of the police and the government. So there's certainly interests at play, and the commissioners need to be aware of this and take that into account when they're making their decisions on procedure. So just take this last week, for example. So instead of having the stoic 6'5" Mountie Stuart Basselt talking about leading off the proceedings with a first-hand account of the initial steps into down Portapique Beach Road, we had kindly self-deprecating legal aid lawyer Roger Burrell giving what amounted to an extended TED Talk to us. And then the issue of the lawyers having to provide their questions in advance. So instead of a witness potentially being surprised by a question or a line of questions on the stand, and perhaps revealing something that they were trying to otherwise conceal, the lawyers for the parties were forced to show their hands, reveal what questions that they intended to ask, and if they didn't do so, they weren't going to get that witness called. The witness wasn't going to be asked to appear by the commission, and we still don't know whether the commission will have witnesses testify. One of the other issues of publishing all of the statements is, it just provides another argument to some of the parties to say, well, we don't need witnesses to testify, they've already given statements. Well, there's issues with that as well, of course. But it all takes some of, like I say, the dramatic energy out of the proceedings, and that only serves the interests of the established, the government and the police. Another strategy that was used this week was something that's done in, I know, governments when they want to release bad news, they either do it at a certain time or they'll do what's called a news dump. They'll issue a whole bunch of bad news or a whole bunch of news at one time. And so that was done here as well. The statements were all released, police reports were released, so we get, instead of a day-by-day revelation of certain facts, which could lead to daily outrage or daily reactions, we have this concentrated release of information, and so the reaction is limited in time and probably in scale, or at least I would think that would be the hope of the police and the government, and perhaps the commission. They've chosen to do it this way, so it's an open question. On top of all of that, of course, the first thing that happens in the proceedings is this very highly technical 911 presentation / witness that really didn't need to lead off proceedings. That could have been something that was done later on in the context of other evidence. So, certainly was a curious decision to start the proceedings in that manner. Now, the commissioners may not consider it their responsibility to be interesting, but they should be aware of how their decisions impact the engagement level of the public. And to the extent that that engagement level is reduced, that serves certain interests. Now, judging by some of the exchanges between the lawyers and some of the commissioners, it's easy to get the sense, particularly I think from Commissioner Stanton in her exchange with Michael Scott from Patterson Law, that the commissioners are inclined to rely on the interviews and witness statements that have been provided, and that somehow this is trauma informed. It really, to them, being trauma informed means avoiding trauma at all costs, even at the cost of accurate fact finding. But if that was their interpretation, we'll see when they make their decisions on witnesses, that would be hardly the most misguided interpretation of the trauma-informed mandate of the Commission. That distinction belongs to the National Police Federation, who attempted to persuade the commissioners that their members, which is all the police officers below the level of staff sergeant, should be exempted from testifying because of the traumatic nature of the circumstances. Never mind that every day in court across this country, police officers are testifying about traumatic situations that they've investigated. But the fact that the National Police Federation even felt that they could make this argument just shows to me how malleable the term trauma-informed has been allowed to appear in these proceedings. But the exchange between when the purported expert that the National Police Federation was trying to have testify, this Dr. Carleton from the University of Regina, when he was testifying and then was cross-examined, it really highlighted the benefits, the potential benefits at least, of effective cross-examination. After Patterson Law's Rob Pinio was finished with Dr. Carleton, it was clear to everybody, I think, and certainly it seemed clear to the commissioners because they rejected him as an expert, that Dr. Carleton was, somebody that had certainly financial interests in the matter with his research for the RCMP. And he hadn't done any personal studies himself. It was a document review that he had written and hadn't examined or spoken even to any of the police officers. And then on top of it all, he'd never been declared an expert in any court proceeding previously. And that fact, which is a very important fact typically in qualifying an expert, how often they've been qualified before, seemed to, I don't know if it caught people off guard at the end, because it was only at the end of his direct examination that was even mentioned. And then Rob Pinio, of course, asked him about that. And Dr. Carleton said he couldn't recall whether he had been named an expert before, which is a certainly unusual thing not to be able to recall. Anyway, none of this that has happened over the last 6 days is fair to the public. Questions as to who is going to testify should have been determined long ago. Should have been done, largely with agreement. If individual witnesses need accommodations because of, their traumatic experiences, they need to testify, behind a screen or in another room with closed circuit or whatever. That can be done, and that could have been discussed before this, So, but here we are, 6 days in, and like I said, we haven't heard from one person who was actually there in the scenario, in the situation in Portapique when this was all happening. And we didn't get that opportunity yet, and we may never get that opportunity. We just don't know yet. And so, I'd say certainly overall, it has been a disorienting approach to evidence presentation, and the public interest has not at all been served by what we've seen in the first 6 days. So we'll watch next week to see what comes of the commissioner's decisions with regard to witnesses. Hopefully they provide some clarity at least as to how they're going to approach these questions, and then we can move beyond some of these arguments and applications by the parties and get into the evidence itself and finally see what happened and get some answers. All right, so that's everything that I wanted to talk about for the first 6 days. I'll be watching, of course, as always, when the proceedings continue next week, and we'll be back to tell you all about it right here. All right, so thank you for watching, and thank you for listening, and we will see you next time.